So, now I can start with.
Move on.
Move on. I forgot that one. I wasn't looking at my thing. I got all excited about the Pledge of Allegiance. All right, so we're going to start with 0 Horseneck Road, which is a hearing on an administrative appeal of Robert Haynes III and Shauna Kessler from a letter issued by the Building and Zoning Enforcement Officer that the property is undevelopable land at 0 Horseneck Road. So are the representatives here?
Here. Does it matter?
Usually right there.
Describe what you,
Yeah.
describe the process.
Okay. So the petitioner here is going to tell us any pertinent information, and then we'll question you, and then the board will open up the hearing to the public, and then the board will close the hearing when we're satisfied, and then vote on the matter. So the voting members here is Derek Catino, Roger Menard, myself, Cynthia Gazakowicz, Constance Gee, and George
Stelgis.
Stelgis. So,
Thank you,
why not
Mrs.
say your name and
Yeah.
address, right?
Michael McVeigh from Markey and Walsh for the applicant and the owner. Thank you, Madam Chair and members of the board, coming before you tonight to request a continuance, pursuant to some comments made by town council where just earlier today submitted paperwork to get onto the next agenda for the planning board to determine the adequacy of the way. So this hearing, we'd like to just maintain the eligibility of the hearing until your next meeting.
And just so the public knows, the board asked for town council to opine on this matter for us, and they wrote a memo, which we shared with the applicants, so and that's the reason why they want to gather some more information before they move forward on this matter. So unless anybody out in the,
You have the,
anybody in the audience have any issues why it shouldn't be,
Maria, you have the
Continued.
paperwork for that?
then Maria will give the paperwork to,
I do have a question. Are you anticipating that you'll be back here?
I do. I think so.
What I would like to suggest, if you do come back here, if you could get the illegible statements and evidence and so forth that you were presenting, and have it maybe translated and written in, understandable English, because we couldn't read a lot of that, and that's part of, I think, why the concern was.
Yeah, I understand. The 1836 deed, I ran through several filters. I transcribed it.
Yeah.
I made it, and I found another
You
deed.
did transcribe it?
I did, not anything before this board, but before the submittal package I gave to the planning board earlier today. Much cleaner, easier to read. I went color by numbers very slowly, and I found it in another deed prior to 1953 as well. So if I am before this board again, I certainly will have it blown up, transcribed,
Yeah, that's.
as legible as is
Sort of a
possible.
numbers person, so I need to
I am
have
too.
it laid out.
I am too.
One other thing that would be helpful before the next thing. I went on the GIS system, and it doesn't show the road going anywhere near your property. So GIS isn't necessarily 100% accurate. So if you have something that shows that laneway and how your property abuts to it, that would be helpful. Because all we have right now, from what I can see, is on the GIS system, it stops significantly before your property.
Okay.
And then I did have another item, I believe, on that. If I remember right, from my reading of the plan, in the plan, there was a spot there on the plan for the surveyor to certify to 2 items that were not completed, if I remember right. That's not it. Anyway, in the lower right-hand side of the plan, no, that's the other one. There was a certification where he was certifying to certain things that were pertinent to what this hearing would have been
This is-
about.
If I may, this was the most recent plan produced by Greg Nichols' company,
Okay,
This-
dated what?
2024.
That's the one I'm talking about.
Okay.
But do you happen to have your copy
I
handy,
did
or
not.
anybody? I just, well, I'm asking now because if it
We're asking these questions now because we don't want to have another continuation after a
That's
continuation, so.
I don't either.
So
Because that-
identifying the things that are either not sufficient or we think might be erroneous would be helpful for the next hearing so that we can breeze through the next hearing a little easier.
Understood.
Yeah, it was a, I think that might be it. I'm not sure. Let me just see. Yes, this is it. This, okay? Now, I can't read it because it's too tiny, but I'll give you, I certify that this survey and plan conform to ethical, procedural, and technical standards for the practice of land survey and blah, 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 in the Commonwealth of Massachusetts. I certify that this plan has been prepared in conformity with the rules and regulations of the Registry of Deeds dated January 1st, 2018, and this is the 2024 plan, and where it asks for the registered professional land surveyor to sign it and date it, neither is done. And the second certification is also similar. I certify that the property lines shown are the lines dividing the existing ownerships, and the lines of streets and ways are those of public or private streets or ways already established, and that no new lines or, I'm sorry, no new lines for division of existing ownerships or for new ways are shown. Same thing, no signature, no date. I do think that
I'll
that
fix
could
that.
become
Yep.
important.
Anything else from anybody else? You got something else to say? You got another question?
No.
You were looking,
No, I'm just waiting for him
oh,
to,
he's doing his
April,
continuance?
I understand it's April 15th. Is that correct? Okay.
so once he gets that, you can just read it.
Yeah.
Maria.
All right. I, Michael McVeigh, request the hearing of my petition to be continued until April 15, 2026. Should we add that he's representing the appellants, because it's not his petition? It's, he's saying for himself that requested the hearing on my petition, which is really not his
Not his.
petition. It's the petition of,
I can amend that if.
yeah, just say you're, yeah,
Now, are
the
we
counsel for the,
Are we also asking
Appellants.
for the
Relief.
timeframe to be extended?
oh,
That's the next sentence.
yes. So he's going to fix that, and then we'll,
You said it was in there?
yeah, I'll finish the reading once we get the proper people who are asking for the continuance.
The purpose of the continuation is to provide them an opportunity to provide more evidence. I heard something about going to the planning board, so that's all part of it.
Yeah. Okay, pass it around again.
So it might actually change the facts. And
Correct.
Is April 15th sufficient time?
I think so, that we're tentatively, I was told today, we're on for the March 24 meeting.
Because they do bi-weekly?
Correct.
Yeah.
Yeah.
Okay, and just so you know, I think if you do need to, as you know, you have to come, if you want another continuance, if something transpires at the planning board, you'll still have to appear on the 15th, and additional continuances are additional
$100.
fees, yeah, just so you know. So,
Okay,
first one is,
good to know.
the first continuance is free, and then after that's more than that, then we start charging you. I, Michael McVeigh, as representative for the owner applicant, request that the hearing on my petition be continued until April 15th, 2026. I understand that the deadline for making a decision will be extending accordingly. Signed by Michael McVeigh, March 11th, 2026.
Okay.
Shall we call for a vote?
I'll make a motion to grant the continuance till 6:30 on April 15th.
Second.
Everybody in favor, say aye.
Aye.
Thank you.
Approved. It's going to my head. All right. The next item on the agenda is a continuation hearing on the administrative appeal of the Mr. and Mrs. Maderos for the property located at 683 American Legion Highway for the determination by the building commissioner and zoning enforcement officer, letter dated December 1st, 2025, that the owner, AMA Engineering, is in compliance with condition 1 of the 2020 plan site approval that mandates the owner install and maintain the stormwater and septic systems at all time with no negative impact all site. Again, the subject property is 683 American Legion Highway in Westport. And just, so the question here is if Ralph was correct in making his determination that they were in compliance, so it's the sort of the flip side. So either if we vote yes, then we uphold Ray's letter, and if we vote no, then we, right?
The opposite,
The opposite?
yeah. They're appealing, so
Oh.
if we grant the appeal, that means that we believe that Ralph was incorrect.
Oh, yes. Yeah, so if we grant the appeal, then Ralph was incorrect. If we don't grant the appeal, then Ralph was correct. But the issue at hand is, was his letter correct or not? And that's what we'll be deciding for tonight.
This is a continuation. Maria, who voted on the original?
Yeah,
The 5 members that were.
yeah. I
Okay.
was going to ask you, I wasn't sure when you and Janice was away. So the members voting tonight, again, will be the 5 members who voted on the continuance, which is Jerry Catino, Raj Menard, myself, Cynthia Kazakowicz, Constance Gee, and George Stelz.
Just like it's,
Like it's spelled. I gotta,
Yep.
have to work on that. So we'll open it up to the appellant and their representative, if you want to introduce yourself.
Sure. Good evening. Jim Marsh. I represent Deb and El Maderos, 48 Old County Road. My recollection from the previous hearing was that post-hearing, we would look into whether the town had actually hired a consultant or an engineer to review the system at 683 American Legion Highway. There was some discussion from the building inspector that there were engineers hired that had looked at it and reported on it. So what we did, post-hearing, we did reach out to the building commissioner, spoke with him. In fact, there were no engineers hired, no consultants hired by the town. There was a consultant that was retained for peer review of the Mouse Mill Road project, which is the project that Mr. Wright is part of, which is the property abutting 683. We obtained that report. We provided it to you guys to review. There was, as part of that report, an assessment of this drainage system. A very short assessment was conducted. We provided that to Steve Giosa, our consultant with Site Tech Engineering, and he provided a response, which we've also provided to the board. Essentially, he was saying that they reviewed the system, the design was appropriate. Steve Joseph doesn't disagree with that. The assessment at the time that there was a rainstorm event that occurred, but that storm event was a one-year storm event, and that type of one-year storm event's not really an appropriate indicator of the system's current capacity or function, which is really the problem here. I think we're not getting to the point where we've had a comprehensive review of this system to see if it actually is functioning. So in subsequent to that, the building commissioner did receive some maintenance records from AMA, the owner of the property at 683. These were provided, I believe, Friday of last week. The records do show from, I think it's 2016 on. 2016 on through the present. But with respect to these records that were provided, there's some doubts as to the accuracy of what is reported in these records. For one, they were provided last minute. It took over 2 months to provide them to it seemed like 2 months to provide it to the building commissioner, where we left this board meeting where they had indicated that they had the records, they could provide them right away, but they didn't. These records that were provided seem to show something which is unusual, where the system, according to the records, was checked, at a point back in 23, this was in November, and within 18 weeks of that date, there were 5 events that flooded out my client's property. That there was water coming from the swale, that breached the swale and would flow onto my client's property. And actually, there was there's records here of an April 24 maintenance that was within 28 days of when there was again, an overflow on May 16th. So, are these records deficient? Are they actually conducting the maintenance? That's why we're calling serious doubts into what's been provided. In addition to all that, each one of these reports indicates that William Andrew Wright was either the inspector or part of the maintenance. And I reached out to him some time ago and asked him for these records, and he responded that they weren't available. So they weren't available then. They show up the Friday before. They're deficient. They don't go into specifics about elevations within the swale. They're not checking that. That's the problem here, because what I think has happened is I'm not the engineer, but the capacity has been diminished, and there's a breach on one side closest to my client's property, and that's where the overflow is occurring. Last meeting, we talked about what should happen, or at least we think should happen, is a third-party peer review should conduct a comprehensive review of this system. Or maybe it's simply the area for where the swale is located to see if it's actually functioning. To look at all the photographs that we provided to the board, the town planner, the building commissioner, along with the videos that show this breach. Again, here's photos of the May 16th that I told you that within 28 days after they did their inspection or maintenance. Here's the swale. It's starting to overflow. Here's the fence. And the water's running right under the fence. and then it runs right down, goes downhill and comes right onto our client's property. This is a serious issue that's been going on for too long. We're here because we asked the building commissioner to take enforcement, to require that there be taken, some corrective actions to be taken. They're not. So again, we think that a review by, obviously, I don't think they want our guy to be out there. We don't think that it's appropriate for someone they hire, so I think the town could hire peer review and have it paid by someone other than the town to do a full assessment of this, to come back with a report that says, yeah, we've got a problem here, or, which we would disagree, but they could come back and say that, no, there isn't something here. This is just an extraordinary amount of storm events that have exceeded the capacity of this system.
But you realize, though, that that has nothing to do with an administrative appeal. Absolutely nothing to do with an administrative appeal. The administrative appeal is purely, did Ralph correctly administer the zoning bylaw, yes or no? And that's all we can do is say, he either did it or he didn't. We don't go into what the ramifications are, because that's not part of the administrative appeal.
But it does, because
No,
Mr.
no, it's very clear. Either Ralph was correct in administrating the bylaws, or he wasn't. That's all that we are going to do today, correct?
Correct.
So,
And if he isn't correct, then the next steps is then Ralph will have to go readdress, and then that's when the conversation about
And
inspections.
then you need to go back to the planning board, because this really is a planning board issue.
it's an issue where the enforcement officer is supposed to enforce the condition that's
Right.
laid out in the site plan
Right,
approval.
and that's what we're deciding on.
Correct.
Right.
And his decision not to go forward with enforcement was based on statements made that the system was working right. And he was given evidence from the owner of the property that they've been conducting
Yeah.
maintenance. And I'm telling you tonight that we're calling to serious doubt what has been provided to him. And mind you, these were provided well after the fact, right? They were provided on Friday of last week. So he didn't see these.
Yeah.
Whether these are true and accurate, that's another story, but he didn't see these at the time. He
Right,
made
that's
his
why we
decision not
continued
to
it, so
retain.
we could see these.
Correct, but he didn't make the decision to not take enforcement.
Right, so he could have made the wrong, like,
No,
Mind you, too, he said that the town had hired consultants or engineers to review the system, and that was part of his decision, based on those reports. Again, that's not a true statement.
well, according to the planning board, it is. Planning board notes in their email that in fact they did test that system.
Right.
In 2024, after a 2-inch rainstorm, and found it to be adequate.
Again, my point is, if he reviewed this actual report from MBL, which I don't think he did, this isn't sufficient of an assessment to make a decision not to take enforcement, because it's not a sufficient assessment to show that this system is working
He has,
properly.
excuse me, but we have an email from the town planner, who is responsible for this project, saying that it was adequate. Now, how much more is he going to do? He's not an expert in water management. The planning board is, and the planning board says that it's adequate. He isn't going to overrule the planning board.
right. I mean,
That's not his job.
right, so
Can
even
I-
if he was incorrect, even if his letter was incorrect because he didn't look at the appropriate paperwork, right? We now have we now have what he should have looked at, the maintenance records and the report from MBL. So now we're going to decide if there is an enforcement issue. So it's sort of it is really saying if he was correct, it's splitting hairs if you're saying that he made his decision incorrectly because he didn't have the right information in hand. We now have the right information in hand, and we're going to make a decision on that. And that is all we're going to make. Have AMA complied with the provisions of their permit to maintain the system?
As
Now,
designed.
As designed. which is critical because there could be other reasons why the system as designed is now currently not adequate to protect your client's property. We don't know that. And we are not the finders of facts to that. You have provided no evidence. You are alleging that those records are inaccurate and falsified. That is not a zoning board decision that you've got to go to civil court for that because we cannot make that determination. We have to look at the face and we have to believe that our property owner in the town of Westport has provided us accurate, unfalsified records, and that's all we can do. So in my mind, and I don't know about my rest of the boards, those records show that they are complying with the maintenance. Yes, you have seen water. You have seen water go over from that property to your client's property, but also in 2020, and you sort of said it was sort of happening 2023-ish, I think if I remember from last time. In 2023, the business next door put up a whole new building and repaved their lot. I think reasonably, that could be causing the system that the town planner has deemed to be adequate at the time in 2012 is now not adequate, but we can't do anything about that. If you think your client has a case of damage to their property, this is a negligent case for the civil court. I mean, we can't take it's a he said, you said, that they provided us records. We have to believe that they're true. Why would they falsify the records? You may think they're falsified. What are you going to say into a court of law that why you think they were falsified? That they waited too long to give them to us, and he said he wasn't going to give them to us? I mean,
I'm going to say that if you look at them, why are the maintenance records showing certain times that they were out there on a certain date, and then within a short period of time, you've got, I think it was 4 events.
Yeah,
that
too much
caused-
water.
And then they do it, and 28 days later, another storm event causes flooding? That's showing that these are deficient.
No,
I'm
No.
not saying that they're falsified, I'm saying they're deficient. They're not doing their job with respect to the maintenance record.
Because what happened was, the 28 days passed, the water came out of the system into the groundwater, and then we got more water. That's why they're saying it was clear. It all went to the water. And then when it came again, there was no place for the water to go. I live in Westport. We all live in Westport. There's a lot of places in Westport, there's a lot of water, and this is one of them. And I don't find it, I have property that sometimes is underwater, and then, it just all of a sudden disappears, and then next thing you know, it's back again.
We've also showed you actual evidence where the swale is being breached and how the water then travels from that location down into my client's property. So
You haven't proven the swale is not built to spec of 2025.
I'm not saying it's not built to spec. It was designed appropriately. It was likely built according to design. But because it hasn't been maintained since 2012, it's now failing.
Well,
You haven't
evidently,
given us any evidence of that.
Oh my God, yes, I have. I've shown you
evidently, the
enough.
planning board doesn't agree with you because they had a surveyor go out and review it after a 2-inch rainstorm and found it to be entirely adequate.
Yeah, but that assessment is not adequate. Where is, let me ask you this question. You just said that Michael Burris had said to him that the system worked. I don't have that email. Do you have that
Yes.
correspondence? I provided you.
You want to read it into record?
I don't know why I don't have a copy of that.
Because it was communication between our planner and,
I-
there's other avenues to address this, which would actually be more beneficial to your client.
Okay, in 2024.
We tried to, through-
No, I'm
AMAM
talking about civil court.
No, we're not
And they can get damages and all the money they've spent already to do what they needed to do.
The town issues a permit to someone. They're supposed to follow it. If they
Yeah.
don't follow it, it's the town's obligation
Yeah.
through their
And-
enforcement agent to
And
require that it be
Again, we haven't
followed.
voted on the matter, but I think at least for, again, in my opinion, what the evidence in the record says that they are complying with their permit.
And according to the town planner, they've done it at least twice in 2021 and 2024.
We've talked to Michael Burris several times, and the only thing we've ever got from him was this MBL.
No.
So I don't know who's hiding the ball in the town, because the information that we're being told is not correct, and that's what was stated throughout my letter to you here, that that there have been consultants hired, but they haven't been hired, and the only one that's actually done an assessment was through peer review of this other project. And it was a small memorandum about the design, which we agree with, and an assessment after a one-year storm event. That's not sufficient. And if he's relying on this and not taking enforcement, then, again, that's what we're going to, that he needs to support what he did. He didn't take enforcement, and he's relying on what? Maintenance reports that haven't showed up until
Again,
yesterday.
it doesn't matter what
And a report.
you relied upon now.
That's not sufficient.
We are relying upon the maintenance records and the report from, and our discussions with the planning board.
And all the videos and photographs that show the system failing?
You don't know the system's failing. There's two things that could be
I
happening.
can see it.
No, the system is either failing, or it is, in X amount of years later, 12 years later, it is inadequate for where it is located because of other things that has occurred in the area. There's one or two, that's it, right? We can get it, we can go and get somebody to do it. And what would happen if all of us, if we got a third party and they said it is working as designed? Then what? Then what would you do?
Then, then.
Which is, by the way,
Listen to a
planning
third
board.
party who's actually done a comprehensive review of this system.
The third party
why-
review
that's
isn't.
what I'm asking.
The third party review is a third party.
But that isn't our job. Our job is to decide whether or not Ralph was correct, period. We are not getting a third party because we don't do that work. That's a planning board job. In fact, that's what you should have done in the first place and gone back to the planning board and said, we need to have this reevaluated.
We've been asking for assistance from this town to deal with this issue through the building inspector's office, the town planner's office, and now we're here at the zoning board. And again, we're getting the door shut to us.
Only because our hands are tied as far as what we can do. You only ask for an administrative appeal. Administrative appeals are very, very straightforward and very precise. It's yes or it's no. Either Ralph was correct or he was not correct in
all
how
we
he
can do.
administered.
That's fine.
And we
And
look
he's
at the
not-
documentation,
he needs to take
so
enforcement.
there were two things that, in my opinion, there were two things that are required. One, did they keep maintenance records? And I agree with Vice Chair said that they provided records. It's not our job to decide whether they are bogus or not. We have to take them as face value as being correct. The other part, have they been maintained? We have documentation from the planning board said that in at least two occasions they were evaluated and determined to be working as designed. So
Yeah.
what else can, I mean,
Yeah.
that's all
You're-
that's all we're here for.
You're relying
Because this is an
on,
administrative appeal, that's all we can do.
your arguments are relying on a principle of negligence, res ipsa, right? You're saying, just because they're at fault, and we are not a court of law. We can only decide on if Ralph was correct or not. And what we have in front of us, at least in my opinion, and again, I'm not speaking for the rest of the board, that there are maintenance records that we have to believe are correct, and there's a report saying that the system appears to be functioning as designed. So there's nothing else we can do. We can't compel a third-party engineer to trespass on their property. I mean, that's what we would be telling, that's what we would be doing.
By
We
agreement.
can't, we don't have the power to do that.
It'd be by agreement.
And that's not in the.
But why would they agree to the facts why would they agree to, that, what if it comes out in your favor? Then why would they agree to have to spend more money
Or-
that they're already spent? I mean, who wouldn't, in the right mind, would do that?
Or
I
if
mean, maybe
not
they
by-
will. I mean, we can
not
ask
by
them if they
agreement,
will,
then
but,
he's got enforcement action. He can require that
Right.
there be an inspection be done. It's as simple as that.
as I said, I don't think there's an enforcement. I think Ralph was correct on his,
Ralph's
on his
correct.
letter.
We're going-
Again, it's not what Ralph looked at when he made that letter.
Well, he
It's
did
what we're
say,
looking
he
at
did
now.
say that he
Yeah,
had
it is.
talked to the AMA, and AMA verbally said they had the record.
And
So
we,
he
as
took
a
that at
board,
face value.
recorded, we, as a board, required paper records. So I would hope in the future, when Ray has another issue similar to this, that he will make sure he gets the paper records before he actually issues his letter. So it's a learning experience for Ralph, as well as how we're going to be handling things, as well as a learning experience for us. So their records, That's what the zoning, that's what the permit said. It said, maintain, they've maintained. If you have a question about the adequacy of the maintenance, you have another avenue. You can go to civil court. And if civil court says that we have to, on our dime, get that inspected, then that's what we'll do. But right now, the evidence in front of me is clear that the AMA is doing what they are supposed to do during their permit. You have not provided any concrete evidence other than the fact that their land is flooding. There could be, as I've said before, as I said last time, there could be countless of other reasons of why that system now is not adequate, but it could still be functioning correctly. And you have provided no concrete evidence that it's not functioning correctly, other than the fact that there's water. But doesn't mean, you haven't said that we've had, an unusual amount of lack of rain, that it's therefore it isn't. There is, I know over the last few years it's been raining like crazy here.
all
So
right.
it may not be adequate for the current conditions of the land and global warming.
Well, that's a
right?
problem for them, because.
No, it's not.
No, it is, because the system
Has
was
to-
designed and installed, and there's a condition within that site plan approval that requires them to maintain the system.
To
If they can't maintain it because,
But they may
because
be,
of other things have happened,
they're maintaining it.
but they're not, because it's now
But it's
impacting
functioning.
off-site.
No, the argue is if they're maintaining it and it's functioning as designed, that's not their problem. That it's now as designed is not adequate.
I don't
They-
agree.
They can't go, you can't ask them to go redo something after we've told them this is how you have to do it, and they complied with everything and got the permit for it.
We're going around in circles,
Yeah,
so let's
Yeah.
move on.
yeah. I think we should have you said everything you would like to say? If not, well, I think there's
Yeah, just
an individual in
just
the.
keep in mind, the applicant and any successor in interest agrees and shall, as a condition of this approval, install and maintain the stormwater and septic systems at all times. In addition, there shall be no negative impacts off-site. In addition to maintaining and installing and installing the approved system.
Yeah.
So it's in addition.
There's no,
And-
there's no evidence to me that says that it's due to the fact that there is no clear
I don't
evidence
know.
beyond a reasonable doubt that it's their system that is causing this, in my opinion. And again,
we-
there's 5 of us here.
I'd like to say something about that. You had indicated earlier that you felt that it was a subsequent construction of a
Good,
building.
it's right next door.
Could be.
Okay? And that was approved by somebody. And I assume the
Right.
planning board, okay? So it may not be this engineering company, it may be a subsequent decision of the planning board, who at that point had to have said, this is, whatever they approve for that second project, or third project, or fifth project, or whatever they've done, that they were certifying through professional assistance, that would be fine. And I assume the same thing, not have negative effects on the neighborhood. So perhaps it may still be a problem, but not necessarily of the making of this particular one.
Exactly, and there's no evidence to suggest otherwise. I mean, like, if there was, it's just too speculative for us to require that somebody pays for a inspection, and that we require that that inspector goes on to another person's private property.
When we were considering the 40B in that area, even though it was somewhat distant from this particular lot, this whole area that's being discussed was brought up as part of
Yeah, because of
the
the Mouse
issues.
Mill- because of the Mouse Mill
Because
Road.
of that area, the
Right.
Mouse Mill area.
Yeah.
So it's very hard to pinpoint exactly whose
That fault.
property it's coming from and so forth.
Since
or who-
there's been buildings since the fact that AMA has built their things
Right.
in the area, either other businesses, the mobile station,
Yeah,
right?
yeah, yeah.
Except for that we also saw that in that case, that the planning board agreed to something and then did not follow up.
Yeah. well,
And, I mean.
Well, that's not us, that's not
Yeah.
us.
I know, but just to
No,
let,
I'm not saying that I'm not sympathetic to the applicants and the homeowners, I
Right.
am, like, absolutely.
it's not like this doesn't happen.
But we can only do what we're authorized to do, and what I'd like, actually, I was thinking about this today. Remember, we are appointed by the select board. The planning, if you don't like what the planning board is doing,
Vote on it.
they're voted in. So all of, Westport residents should think hard and long about who they vote in for the planning board, because that's what the citizens of this town are voting in the planning board. They didn't vote in us. We're appointed, right? And we are only here to enforce the laws. We don't even write the laws we have to enforce. The planning board does. So I understand that you've had frustration with the planning board, and I, again, would argue that then, that the townspeople need to, take note, because as Constance says, this is not the first time that there's been people with issues with the planning board.
You want to open it up to the public?
Yeah,
Could I ask one question? What would be adequate evidence for us
beyond
to?
a reasonable doubt, don't you think? I mean,
No, I mean, like, what type of evidence?
I think it would be
Civil
preponderance of the
engineering
evidence,
report,
but-
or,
If the,
That's even harder.
if the,
No, I think
if
we're
the
50
planning
minutes.
board, the planning board has a contractor that went out and evaluated. If they came back and said, we believe it's been improperly maintained, then
but I'm
that
thinking-
would be,
I think we do need to read the sentence that there is an additional requirement that
Mm-hmm.
it not intrude on.
but it's still based on the design. We can't
We
enforce
can't- we
something.
can't- we
that
can't
a-
enforce
The town
it.
approved the design.
Right.
We can't require something in excess of what
Well,
was
let's say-
already approved by the
Let's say
town.
hypothetically, there's a constant flow of
Yeah.
water, and Ralph didn't enforce it.
but
But
what,
there's just a constant flow of water. That would be clear.
No,
that
no.
there is an
if
intrusion.
the system
wouldn't.
is working as designed, it's not.
If it was working as,
Then why did they write in that sentence an "and"?
no,
It's a
Well,
two-pronged.
that's-
it's a
That's
two-
not for
that's
us.
that's how they write a decision, but
Yeah.
that's,
Yeah,
still, we can only enforce
We could only,
the planning board approved a design.
Right.
We can't require it to do something beyond the capability of that design, because it's already been approved.
and to the appellant's thing, it had been working for quite some time. So it's a reason, I mean, I don't say it's not a unreasonable conclusion that it could be from poor maintenance, but I think there's other reasons why that it's not functioning, it's that you're getting water onto the homeowner's lot. There could be, there's just too many other variables there for us to say that it's definitely lack of maintenance.
But it's the system, and it's owned by the property owner. And
Right, and we've
As-
shown that it's been maintained.
as,
It's been
as
maintained.
well said, there's an in addition, and there's offsite impacts to
Yeah.
my client's property.
But they can't,
Due
that
to that
couldn't be
system.
future. You can't, nobody would say that would be to future changes in the topography of the area. No, I mean, find me some case law.
That's part of the
Fi-
risk of
find-
owning property.
Find me some case law that says that we can we can say the permit has to do more than what we gave it to do because of changes that happened after the permit was issued. Can you find that case law?
Stormwater regulations require you can't dump more water on someone else's property. That
Right.
existed.
But we don't know they're dumping it. They're not dumping
It's
it.
coming out of the system. It's directly coming from the system.
Yes, but where is it coming from to get
The
into
system.
the system? No, but it's coming into the system from the environment.
We're still going round and around.
Yeah, we're going-
It's the same-
yeah.
It's the same circular argument.
Yeah, so I
Let me
think,
just lastly say, I mean, he made his decision, we're basing the appeal on the decision, the day he sat there and wrote the decision. The maintenance records were not part of his record at the time that he made that decision.
No, but he
No, I
did
know.
get, he said in the letter that he had talked to them and isn't that correct? And they said that they had been maintaining it. He took that as face value. So now we have the records that support that.
Right. If the records didn't support that, then that would be a different story, but the records support Ralph's belief from when he spoke with the rights. or
I'd like to
whoever he
ask a
spoke with.
different question. If, if someone were to maintain what you're asking for, that, would there not be some physical, visible evidence of that maintenance? Either lawn disturbed or cut or whatever they do to maintain it? Wouldn't there be some physical, visible thing? And if so, why can't we see?
I think no, there was, in the maintenance records, there were pictures attached. So say when they cut the lawn and they did other stuff, and there was actually a picture of, the,
Well, because those pictures only came Friday,
Yeah.
I haven't even had a chance to look through them. So I think we're jumping the gun slightly on that.
well, I mean, I guess
But I mean,
We can-
that doesn't necessarily mean that Ralph did or didn't make the right decision.
Right.
But I'm saying, it seems to me, the company would and should be able to show evidence, physical evidence on the ground that they've been doing what they're supposed to be doing, whatever that is.
That's-
But I'm not seeing that, but you're saying it does show that in the pictures?
yeah.
You
Yeah,
have,
what was attached to that big, I didn't print it because it was too many pages and I was trying to save some paper, but there were pictures of, trimming the vegetation back. Oh, is it here?
We don't know where these came from.
Even-
yeah, and they have dates and,
But again, that's not for us, we are not a court of law to decide the veracity of
Right,
this
but that's my
data.
point, is if you're
And-
saying that we're not showing proof of the system not functioning because we don't have the preponderance of the evidence to show evidence that
Right.
this water is spilling onto our property, well, are we gonna take these on face value and these photos?
I don't know what those.
In my opinion,
When were these taken?
in my opinion,
What
though,
are they
that's
showing?
totally irrelevant. We asked for maintenance records, they provided us maintenance records.
It's the
So the
holding tank.
that's
yeah.
all that the decision said was that they maintain it according to the records, they have maintained it. Whether these pictures are good or bad, I don't really care. All we asked for was, did you maintain the system? They provided records saying they did maintain the system.
And they also said that they could have them to us immediately because they had them, and they didn't get them to us immediately.
We also had 2 major snow events.
Come on, I mean,
But
you
again-
could have turned it, you go over, you pick up the file, you walk down to town hall, and you give it to the building commissioner. It doesn't
Again,
take
but
2 months.
we have no authority to slap them on the hand that they didn't provide them.
Post haste.
I think it
post-haste.
smells, I
Like,
really
we don't, well, you can, and then go to civil court.
No, but the
Go to
problem
civil
is,
court.
you should see that as well and see that there's a problem here in what he's supporting his decision on. I really do.
But I think what we're circling around on is that what Ralph had in front of him led to a proper decision. I think the inadequacy is probably what has been pointed out a number of times as the evidence.
Yeah.
And that we're looking at a couple of photographs and statements,
Right.
which, as Cynthia said, it's sort of a he said, she said.
Yeah.
And so when you put that, as that was Ralph's, what was visible to Ralph, his determination was likely very reasonable.
Yeah.
So I think that based on what everybody's honing in on, is it's the evidentiary record brought by your clients.
Which was very thorough.
But was it thorough? There's a couple of pages of.
A couple of pages.
Bunch of pictures.
We gave you guys a flash drive that showed video after video
But if,
and storm event after storm event. I don't know if you're not getting it, not
no,
reviewing it.
no, we got it.
Yep.
And I understand, I mean, again, it's not that we don't, we don't, we understand there's a problem on your client's property. What what I don't see is that it's clearly AMA's responsibility. It could be other factors out there that are numerous, that, other than the fact that they've complied and given us records, albeit late, they did, and I do remember they said they would bring them right away, but they didn't, right? But if they weren't even here last time for us to ask, remember, AMA is not part of this appeal,
I know, but they were here. as
They were here, and if
public
they weren't here,
participants. Yep.
right? Then we would never have gotten those records. So we would have, we may have decided differently for with Ralph's decision, because there wasn't any record. But now there is evidence that they have been maintaining it. There is nothing more we can do.
I think this goes beyond, back beyond their being here at a hearing. I think it goes to what Ralph was provided when he made whatever decision he was going to make. So, in other words, like, I don't know, I haven't heard yet that Ralph said that he went out there 5 times after a water event. He went there and saw the actual maintenance that was being done or not being done. I don't know any of
But
that.
Ralph wouldn't, that wouldn't be Ralph's job. Ralph wouldn't do that.
Well, it was according to the planning board.
Why wouldn't
It
he?
was his
No,
responsibility.
this-
What's that?
No, that's not,
Why wouldn't he witness it? Yeah.
no.
Why wouldn't he go over there and ask to see the
Yeah, that's what I'm
system?
saying. Ralph,
He didn't.
you did ask for records of this, didn't you? And did you get adequate records of it?
I got the records that I got.
Just recently,
Yeah.
right.
No, I'm talking about way back before this.
Way back was what I reviewed, what I supplied, they did a few site visits to it. The site visits, again, I'm not an engineer.
Right.
Right,
The system was working, to me it was working,
right. And being maintained,
in
in
my
your
opinion,
opinion.
because it was clean.
My understanding is you tried to get over there several times and you weren't able to. You left your card several times. The door was locked at one point. You had no access.
I won't go on anybody's property unless I let the owner know I'm there.
Right, so that's my point. You
So I
didn't
just
witness
won't
it.
walk in the backyard, or even would it be your backyard, anybody's backyard. My card goes in the door. When they respond to me and with the card, then we make arrangements.
But they didn't respond, and that's my point, is that's what I understand from
They
you.
did respond.
You discussing that with my client. So, I don't think there was any, as you say, on-site, that where he may have reviewed the system, inspected the system, saw the records, which they may have had in a file. That didn't happen.
Well, and it may not have.
This is
Maybe-
inadequate.
So maybe Ralph made the wrong decision. But with the evidence we have now, it was the right, in my opinion, it was the right decision.
I think he wasn't given adequate information to make any other.
Right, and that's why we
decision.
asked for more information.
Right,
And
that's
now
why
we have it.
did. But we're being asked to determine whether he made the right decision, which was made long before this hearing, was,
Right, so what are we gonna say? We're gonna say he made the wrong decision, and then,
No.
we're gonna have him go and then you're gonna have another then we're gonna have another inspection, and then they're gonna go back and we're gonna say it was the right decision because he looked at this paperwork. That's kind of a little
no.
bit
I,
backwards.
I say that he made the right decision based on the information he had at the time.
Right.
That's the difference.
Okay. Where a counselor is saying that he didn't.
Did you just say, Jerry, that you thought that he did make the right decision based on the information he had at the time?
Yeah, that's what I'm saying.
You can open it to the public.
Yes, this poor woman here has been wanting to talk. So stand up to the mic and give your name and address.
I'm Deb Maderas, 48 Old County Road. Attorney Marsh
Yeah.
is our attorney. I'd like to show you is the as-built plan, because that's going to show you where the water is coming over. It's supposed to follow that whole trail, and it is not. It's only going to the first one, and it's getting diverted. And that's why it's coming over. And he has the as-built plan. I'll show you exactly where it's coming over. This isn't following what it's supposed to be.
Whether, I mean, you can show it to us, but we're not experts in water management. The planning board says it's working properly.
Your.
We're not going to overrule the planning board's
And your own
consultant that says it's
engineer-
working.
their own engineer said it was built properly, so.
It is built properly, but what I'm trying to tell you is, this is it here, so everybody can see it. This is it here, okay? The water is in the pipes here, and it comes out of the outlet pipe here, and it's supposed to go all the way down to this corner. And what is happening is, before it gets to this first check dam, that slows it down. It's not, it's diverting down here
Right. So,
and coming through our property.
so what you're saying was there was a fault in the as-built. That's not our
No, I'm
responsibility.
No,
not
it's a
saying
fault
if
in the
there's
current
fault in
system.
the as-built. I'm saying that
It's supposed to flow all the way
something
through.
has eroded away here, so it's not letting it go the way it's supposed to this southeast corner.
Right.
It's evading all this. This is why we're getting flooded, because all that water should be held here, and it's supposed to,
Infiltrate, yeah.
yes. And it's not getting past this, so it's diverted here, so we're getting all this water flooded at once.
So Chairwoman, to your point, if there are other factors that are playing into more water in the system, I think that's where you're going.
Yeah.
It's not getting to the point where it was supposed to go to.
Then how do we get an independent assessment of this saying that it's working as designed?
Because it was done during a one-year storm.
A 2-year,
Or a 2-year.
it was
This is
a
a
2-inch
100
storm, and they said it was working
This
as
is-
designed.
This is up to a 100-year storm event.
Yep.
A 2-year storm,
A
Is it
2-inch
dribble?
storm. 2-inch storm.
2-inch storm.
A 2-inch storm. That's not a dribble.
It's a dribble compared to what this system
That's not a
should be
dribble.
holding.
And it said it was working as designed. What else can we go on?
Yeah. It might not have been designed correctly for a 100-year storm.
And that's where I think it's the
That's-
planning board's responsibility to see that this gets dealt with properly.
And here's the evidence. I mean, this water is supposed to go all the way down to where this fence is and stay in there, and it isn't. It's being diverted right here.
Under the fence.
And then it goes under the fence, there's the fence, and it comes over to my neighbor. This is my property, it comes through there, and there's quite a bit of water here. Sometimes it was 20 feet across. And then that's our property, it comes across there, and that's what it looks like when it's dry, that particular spot where it's being diverted. That's what it looks like.
This could be a relatively.
So it's right
quick fix.
here that it's coming through.
If someone would take
So that's,
Why isn't,
a position
that's what's happening.
and say that this is not working, if all it needs to do is fix this side of the swale to keep the water from coming over, why does my client have to keep doing the runaround here?
For 2
The
years.
system's not functioning right. It should be enforced that this swale get fixed. It's not a hard ask, really.
I agree with you completely.
Thank you.
Any other public? No other public comments?
We will make a decision. Myself, I'd like to see it, given some time to see what the planning board would say about this. But I'm prepared to make a decision that
The planning board already-
he did the best he could with what he had. I don't know whether he was ever invited to go to the Madeira's property and stand there and see this water. But if he did, as he says, he's not a water engineer. I mean, the guy's got enough problems trying to deal with everything he's got over there, besides dealing with us. So I think that it really needs to go back to the planning board and say, okay, you guys approved all this, look what's happened. And get them, they hire consulting engineers to
I
take
agree.
care of their stuff.
But-
And so I don't think that the town should allow this to go on, but it's just a matter of how does it get solved? And it's almost, from this last presentation, it seemed like it would not be a huge deal to at least fix that big piece there.
Right, but I think it's the planning board
Yeah.
responsibility.
Again, that's what I'm saying.
Well, how do we make it so that the planning
Well,
board?
before we
How
get
do we
on to the
get it?
discussion, shouldn't we close the hearing and then discuss?
Okay.
Yeah?
Okay, if there's no other, I make a motion to close the hearing?
Second.
All,
Meeting closed.
no, you did say all in favor.
All in favor? Oh, all in favor? Aye.
Aye. Tell them,
All right.
tell them what that means.
So the meeting's closed. We'll take no more comments from the audience or from the applicant unless we ask a question. So
All right, discussion.
I think I made my point very clear. The provision requires maintenance. They've shown its maintenance. It's not us for decide if that maintenance is adequate, falsified, or otherwise. We have a letter from, one of the engineers that the town uses regularly for various matters, or has come before us for, as applicants, engineers, and saying that it's functioning as designed. They did have some they did make some recommendations here, which they also said has been corrected. So in my opinion, I think Ralph made the right decision. Perhaps, I'm not gonna be as bold as Jerry saying that he made the right decision with what he had in hand. I think, in future times, I think I'd really encourage Ralph to get things on
In writing.
paper. But, I think in hindsight, he made the right decision.
Right? Yeah, I mean, I just go back to what an administrative appeal is. We are either saying that Ralph correctly administered the bylaw or not, and I can't see any reason why he didn't. We have records that show that it was maintained, and a memo from the planning board that said, in fact, it was inspected. And even in Ralph's letter, he said he had at least verbal confirmation from AMA saying that it was maintained. So I have no rationale for saying that he did not correctly administer the bylaw.
Not to say that there isn't not a water problem on.
Absolutely, absolutely.
On
Yeah,
the applicant's property, but I think it becomes the planning board issue or a civil issue, either, against AMA or against the town. I mean,
Right.
And that is the recourse, is to ask Ralph for enforcement if there is a violation of the planning.
right, and right now,
Detail, right?
that's all he can do is enforce.
Yeah, exactly.
That.
But do we all agree that part of the prescription from the planning board for the site plan is that they build a system, and that system, and that the water not intrude on the neighbor's
Right.
property? I see those as very
Yeah.
disconnected items. I can't
Well,
imagine, well, let me explain. I can't imagine that the planning board would say, if you build a system like this, and then all the water floods the neighbor's property, you've met your burden. I don't think that would have been their intention, so I do think it is proper to read them
Right.
to live alone.
But we also can't, but
Exactly.
it's on the record that there hadn't had a problem for the first 10 years. So I look at that as that something else has happened. And.
Well, I don't
we
even know if we have to speculate about
Right.
that, you know?
Well,
We
well-
look at whatever Ralph had in front of him.
Right, but we can't ask them, we can't ask the AMA to, we can't interpret not allowing the water to infiltrate neighboring properties in perpetuity, based on weather conditions, other building around them. I personally can't
What I was-
read that far, and I don't think it's actually a zoning board's actually,
Well, let's flip
I
it.
don't think it's
Let's
a
say,
zoning board's this,
what if this was a situation where
Purview to
Ralph
interpret that.
enforced?
I'm sorry, say that
What
again.
if it was a situation where Ralph did enforce and did determine that there was enough water intrusion to be violating the planning board's plan? How would we feel?
Well, then they wouldn't be coming to us.
Well, yeah, of course. I'm
Yeah.
just-
They
I keep
they
seeing-
would be if nobody
AMA
did
might
anything
become-
about it.
right,
And
and
they
then,
might be-
and then Ralph, as a zoning enforcement officer, would have to enforce that, i.e. would have to go to AMA. But
even
we
then,
don't
it-
enforce, we don't enforce the zoning bylaws.
Even then, they wouldn't be coming to us because he's still correct.
I think he could be correct potentially either way in this.
Then
So
they would probably have appealed
what
and
we're
said that
asked
he
to
was
do is
incorrect.
overturn him, and it seems like it's a situation where there's just not enough to override Ralph's
Right.
professional judgment.
Right. I mean, because if you,
But Ralph says he doesn't have professional judgment.
Well, you
I
know,
mean,
as,
he's-
as.
Well, no, he is supposed to be the planning board's, he's the planning board's appointed enforcement officer.
Exactly.
But he's told us repeatedly that this isn't, he doesn't know anything about.
well,
He doesn't know anything about this, and this isn't his bailiwick. So this is a problem that if he is supposed to be enforcing what the planning board has laid out there, and he doesn't have the ability to do that, knowledge-wise, and he.
Well, I think these are just hard. It doesn't rain every day. The water's not flowing every day, so you sort of have to catch it. And you might need to see it in action, but yeah, to your point. it's
But, I
a
mean, so
complicated
it's-
Situation, and that's,
So then if he doesn't have the professional ability to make this decision, to say if a drainage system is working or not.
and we elected to have a
Wait,
select board.
then, I'm sorry, then he could have very well made the wrong decision because he doesn't know. And I'm not blaming Ralph. I'm just saying that the way it is set up, it set him up to fail. I mean, he can't make it the right, how can he make that decision?
Nor
If he
can
does-
we, right? All we can say is what we see. We're not, none of us are experts on water, on water either. So that's why there is other avenues to address this issue.
There's always supposed to be another avenue. It's always
Yeah.
getting kicked to, kicked down to
No,
another committee.
No, I'm saying actually go to court and sue AMA. That's what I'm saying. If they really believe it's AMA, then they need to prove it in court. And so I think to your situation, if you would have, if you made it that Ralph said that there was an enforcement issue, right? What would have happened? AMA would have appealed.
Right.
That's what would have happened.
Well, wouldn't the planning board have gotten involved and said, this isn't working in terms of what we had required of this company? And therefore, the planning board would have had to step in and,
Yes.
well, so I think it should go back to the
I mean,
planning board.
I do have, I think when a neighbor goes through planning board and gets two assurances, one, a system will be put in, and the second assurance that the water will not intrude on their property.
Right.
The grand bargain there is they will not protest, they will not sue. The complainant here chose not to take them to court back then because they got assurances from the planning board that water would not flow into their property.
I think that was, I don't think the planning board could have really make that assurance. I personally.
That was their intention.
Yeah.
Let's at least say that that was their
That's right.
intention. There were two criteria: build the system and that you won't have water flowing onto your property. And
And
in
for-
exchange for that, they didn't take them to court to fight
Can I
them.
amend that just a little bit?
Yeah.
It's not any more than what already exists.
Exactly. So
And
this is
that's a
where
big
I'm-
point, because
Yeah.
the water is, because that property's always been wet.
This is what I'm getting back to, is I keep coming to this really is turned into a he said, she said with inadequate evidence on both sides, to the point where I think it is totally proper to support Ralph's determination. He was on the ground, he's visited the site. And I think that's the issue, is there's just not enough to say Ralph was wrong. And I think that, nobody wants a situation like this, but at the end of the day, there's got to be better, more professional evidence in order to clear that hurdle that it's no more water than was already present before AMA was built. And then to Cynthia's point, there are extensive other possibilities. So I think that we understand the emotions, but at the same time, you have to realize that both Ralph suffers from, and I think the board here suffers from, the level and precision of the evidence. That's all I would like to say.
Yeah, I think the Conservation Commission would have some role here. I don't know what, but they have an agent, and part of their function is to deal with stormwater management. And so I think that they also ought to be involved. But again, I don't know how you get them there.
Right, I mean, that's the thing, is that,
I mean, we have no
we have no power over
authority to
the
say.
planning board. We don't.
Yeah, planning board or the Conservation Commission, but I do think that if it can be shown, what she showed us at the very last piece
Yeah.
there, that there's something that causing a diversion of the water, I think that's conservation.
Yeah, or DEP.
Describe what it takes to,
Oh, we need a supermajority, don't we?
So,
Yeah, so we need 4 out of 5.
so
in
if
order
they
to-
were to take it to civil court, would they be suing the company or the town, or both?
Depending what they wanted to do. If they thought their evidence against the company was strong enough, they would go against the company.
And what about,
but they would have to sue them based on the design, not the fact that it's water there.
Yeah.
That the design has failed,
Yeah,
and it hasn't been fixed.
Right.
If the
And then-
design, if they go out there and say, it's working as designed, but they're still getting water,
No, they would have the second component of the planning board's
Right. yeah.
statements. I don't think they would need to prove that the system was failing. I think they would need to prove that there's more water than was there before.
yeah. Or the system was failing, and then that would have to
Oh,
be,
yeah, the
they would
system,
have to
of course,
figure
too.
it.
Right.
And even if the system was failing and they fixed it to spec, there still could be water there.
There
So
still
we
could be.
haven't
And that,
addressed all the other
that lack of
reasons.
additional water was a guarantee that the planning board, well, it was an intention of the planning board when they approved the site plan.
you ready to vote?
Well, they have evidence that they did maintenance. They have evidence that the maintenance didn't work.
No,
No?
they don't.
No.
They have evidence.
Well,
that
it's flooding.
They have evidence that their
Flooding.
property is flooding. There is no direct evidence that is coming directly from them, because what one possibility could be is that there is now, because other buildings in the area, which there has been, and a lot more blacktop, that means that their property, that they're getting flooded, that AMA is actually getting flooded, which then by default is now flooding their property. We don't know that there's something out there that isn't causing AMA's system to be overloaded so that what the homeowner just described is occurring, right? That was not in the design of the system. The design of the system was for their property. So we don't know if there is some other property affecting AMA's property, which then inadvertently is affecting
Right.
the applicant's property.
And we have a report saying that it's working as designed, which means it hasn't failed.
But it
It may not be adequate.
Don't
the
believe your
design
eye.
may have
Yeah.
been, the design may not be adequate.
Yeah, it may not be
correct.
adequate.
at this point?
Right,
At this point, which I think is probably the case,
right.
unfortunately.
But I don't think it reflects back on Ralph. I think he did the best
That's
he
what
had,
that's what we're here for.
good with what he had.
So how can they,
I don't think
That's
he
not our
dug into it
problem.
enough.
And I hate to say it like that, but we're here for an administrative appeal, and we have to focus on
Yeah.
what they asked for, and they asked for an administrative appeal.
I mean, I'm happy to say that, as a board, we can go back to the planning board and saying that they needed to address this, go back to the select board and say they need to address this, go back to the town administrator, they need to address this, because you're putting on, it's coming to us, and there's nothing we can do.
Right.
Right.
It's-
And,
But Ralph did not get cooperation from the engineering company when he would go there, and they wouldn't be there, and they wouldn't have him back there, he leaves a card. You know, he's got a lot of work to do.
Well, if he didn't get a cooperation, then he shouldn't have signed up on it.
he eventually did.
Yeah, but he had no reason to say it didn't work.
He eventually got cooperation. We did eventually meet with
Yes.
AMA and talk about, and look at,
Eventually, I was able to get
Yeah.
in, talk about it.
yeah. Just because they
Got the
haven't maybe
information I
been,
got.
just because they have, AMA, right, and I'm just saying speculatively, has maybe not been as responsive as we would have liked, that's not to say that Ralph's decision was wrong. I mean, we can't, just because we think that perhaps that there may be other things going on here, that is not how we make our decision. Our decision is solely based upon was Ralph's letter appropriate? And that's the only thing. It's unfortunate that we can't do anything else. We just gotta say that it's, did Ralph do the right thing? Yes or no? And that's all we can do. We can't take in it's sort of like saying that because they took so long to respond and so long to provide the records, is like saying, back in the day when we've had many times here, is that one of our board members didn't aesthetically like the design of the thing that we were supposed to approve for a variance or like in particular an ADU. That's not, just that personal feeling that we maybe not like the way AMA has responded in this matter should not be part of our decision process at all. It has to do if.
I'm not, I
Yeah.
mean, that's not a part of the decision
Yes,
process.
I'm just clarifying. It's
Me.
really a matter of, did Ralph make the right decision or not?
You
Right.
Make a motion?
You want to, you do that, because you
Well,
understand the
the-
backwardsness of this.
I'm going to get the paperwork out here. According to our lawyers, it is always advisable to make the motion to grant the appeal, because our bylaw says you need 4 members voting in the affirmative to grant the appeal. So in which case, I will make a motion to grant the appeal. And again, this is just a motion, not a vote, of administrative appeal of the Medeiros for the determination by the building commissioner and zoning enforcement officer dated 1/2025 that the owner, AMA Engineering, is in compliance with condition 1 of the site plan approval that mandates that the overall install and maintenance of stormwater system at all times with no impact on off-site. So,
Okay,
anyway,
and then-
I make a motion to approve. We need a second, and then we'll talk about it, then we'll vote.
Second.
Second, okay. We've already talked a whole bunch about it. Again,
So a yes to the appeal means, if we vote yes.
if we vote to grant, we're saying that Ralph was wrong. If we vote to reject, then we're saying that Ralph correctly administered the bylaw.
Okay. Everybody got that? George is looking a little, it's backwards.
It's
yeah.
backwards.
But because the rules say 4 affirmative votes to grant the appeal, not 4 negative votes right? That's why we have to do it this way. So a
Right.
yes vote means Ralph was wrong, a no vote means Ralph was right.
Right, so show of hands for,
I think that as part of the rationale for what we're talking about, I think we clearly should state that we do see a problem, and that it should be referred to the planning board and the conservation
we
commission.
can put that in the decision.
Yeah,
I agree 100% with
me
that.
too. Yeah. And that we should, supply the decision to the.
I don't know how you
Conservation
put
Committee.
that in positive side.
Yeah, I think it's,
No, so-
it's in the minutes, so we'll make sure the decision reflects that. And we'll make sure that the planning board, conservation committee, and I think the select board and the administrator gets a copy of our decision.
So we need to vote for, how many
So-
people want to grant the petition?
So we have one yes,
One yes.
record shows that
How
constant,
many reject?
4 reject.
Notify, notice. But so obviously that failed. Well, I agree with what Jerry said. I think as part of the decision, we should note that there is a serious problem here that really should be taken up by the planning board, because it was a planning board decision in the first place that mandated this.
Right, and
And
also.
they are supposed to be the ones who are enforcing it.
Yeah. And also hopefully they'll learn as they issue other permits, because I think I think the reason why the planning board needs to get involved, I think there's deficiencies within our zoning laws that really limits what we can do. And again, we don't write our own laws, we just have to enforce what the planning board Right, and I don't think it's just, I don't think it's Westport in general, I think a lot of towns have zoning laws that perhaps don't really address.
But I would like to just elaborate just a little bit on what I last said about these other boards, and that is that I'm not necessarily saying that it's this engineering company that's the root cause of all of this, but it's up to the planning board and/or the Conservation Commission to find out what is the problem and find out who should be
And
responsible.
the town needs to, I mean, unfortunately, the town needs to support the planning board and the other boards that have these very, critical decision-making authority. And again, that's why I said earlier, the planning board is elected. You may want to consider who you want to vote for the planning board. You may also want to consider you vote for the select board, because they're the ones who are giving the budgets to the planning board and,
Remind them that there's a 20-day.
oh, and then, so there's a 20-day, right,
process.
appeal process that somebody can appeal our decision,
Either.
either. And then after that, the decision will be recorded with the town.
How do you appeal an appeal?
That's it.
All right, thank you so much. Have a good evening.
Planning board.
I want to thank each and every one of you.
Right, then you go to
Did you thank us?
yes. I think
we have meeting minutes.
yes. So if they want to appeal the zoning board, right? If they want to.
Totally messed up situation. This isn't
No,
the
they,
first
no,
time
no,
that
they appealed
No.
to
we're put in this
land court.
situation.
That's right.
Yeah, I mean, like.
That's right.
yeah,
It's
like-
almost like a
Not
constant.
personally, no offense, Ralph.
If it goes to court, it would
It's
be
not
sent
personal
right
at all.
back
I
to
don't take nothing
us or to the town.
been doing this a long
You
time.
guys work it out.
Well, yeah.
That's what they do.
I know.
That's exactly what the court does.
90% of the cases.
And I
said,
personally
yeah,
have suffered from exactly the
Yeah.
same thing. And I mean, I know how frustrating it is. and
That's
how-
exactly what.
Oh, it's, I don't.
This way.
They don't like to make
I would
decisions, they
be
just said,
livid as
figure it
well,
out.
But I think I would take it a little.
Too much work.
Make yourself happy.
Zoning board.
I think, I mean, just my 10 cents is that the penalties are reasonable when he enforces. There's a per-day fine, I think, of up to $300.
But how can they, but
So-
what
you know-
what are we finding them to do?
No, I'm just
To
saying,
stop the weather?
I think Ralph is properly judicious with
Yeah.
his enforcement. It's
Yeah.
not something that should just be
Yes.
handed out.
Yes.
Right, and then,
Well, they can't
Yes.
get, you can't even get people to pay
They
for it.
fine.
You know, we're
anyway.
we're still on,
right,
Yeah, he has said we have selective enforcement.
Yeah.
right. And the thing is that they can pay a fine, but how are they gonna fix the weather?
Well, it's obvious
think
there's
you meant
something
the right
wrong with
choice.
that place.
We
Well,
support it.
I don't agree.
unfortunately. I mean, sometimes you really hate to do what you got to do,
but-
but the law is the law.
Yeah, we
As
can't,
you, as you said, though, the question is was he right or was he wrong?
Right.
Based on what he had in front of him.
Right.
And
Well, we didn't have
unfortunately-
anything in front of him to begin with when he made the decision.
but we did after the fact, so. Okay, so I guess we have meeting minutes from February 11, 2026, that we need approved. Can the absence member be part of the approval process of the minutes?
No, if you weren't here, you don't vote on it.
Okay, so would someone like to make a motion?
I'll make a motion to approve,
Okay.
I was here. I will
Okay.
make a motion to approve the meeting minutes of
February 11th.
February 11th.
I will second.
Hey,
I was
see?
here.
Yeah,
It's good.
everybody in favor, say aye.
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 Any other business?
No.
So, are you going to sign it and give it back to?
Oh, I gotta
Maria?
sign it? Did I sign it
You were
anywhere?
acting, yeah.
Do I sign it anywhere?
Okay, I'll put my name, I'll sign it.
Okay,
I'll sign it.
all right. Members present, or, oh, it was on the back is where it gets
Yeah,
signed?
at
the end.
Yes, you can sign it, I'll let you, this time.
You can assign me.
I'm assigning you to assign that,
Okay.
because then you can actually read it. Have you ever seen my signature?
Has everybody seen the zoning amendments that are going on, the articles that, for the town meeting? There's like,
I have not.
No,
They're pretty important.
didn't you send them out?
Yeah.
Yeah, I got a
I mean,
few,
I'm
yeah.
sure you sent them out, I'm just
Oh, okay.
behind.
I mean, yeah, there's a few in there, yes.
And what- do-
Those of you on River Road in Adamsville will be very pleased that, that assuming the town meeting votes it, they'll now be allowed to do the food truck.
Maybe.
To do what?
No, not maybe.
Well, no,
Well,
they still have to be, they
they
still have to go through the
meet
process.
Board of Health
Right.
issues, but zoning-wise,
Yep.
we're gonna make a special zone for 5 lots.
Yep.
down
And they're
there
calling it a
that will
village or
allow,
something?
Wait,
thing.
what?
So you remember the.
Adam,
That food
Gra-
truck,
the-
food trailer.
Gray's Daily
Oh.
Grind. So they're actually doing what they should have done years ago.
at Adams area, which already has
Has
business, they're going to
business.
actually
Oh,
make
Make
it
it
into
an
a,
approved business thing, so they'll be able to conduct their business in that area, because now it's a business district, but they still have to go through all
you're
the
still going to go through all the other stuff.
other stuff
Yeah,
which they
there's,
have failed
there
to
are
do
other.
before, so who knows?
They are adjusting the town, the town bylaws to allow food truck things,
Oh, okay.
which we did not have.
Well, what they're,
either.
Well, since
it's not
everything's
just food trucks,
closed
they're
down-
allowing it to be
In Adamsville.
And not just.
like a semi-business.
No,
I get it.
but I'm not talking about the zoning one, I'm talking about the town bylaws that didn't allow.
Oh, right, yes, okay, yes,
Just-
you're right, you're right,
things.
right,
So
they added that to it
we're
as well.
tightening up some of that
Right.
and making it more liberal in many ways.
Right,
But there are still issues, in my opinion, my knowledge of the bylaws, I think there's still issues that they also are dealing with the height of structures in the proposed bylaws,
And
not
dog-
that bylaw,
right.
but,
and dogs,
what's that place?
there's, they're,
Oh, dog.
the dogs, how many dogs you can have.
The dog thing should have been done years ago because
And that's-
we had been
Oh,
out of
correcting
sync.
it to the state rule?
That's right, we're just complying with the state, the new state
That
rule.
was, the dog thing was supposed to come up years ago.
Years ago, right.
And, but on that particular year, because I was a part of that, there were too many other, there were many other more priority zoning things, and the dog thing, all it was just our town bylaw was out of sync
Right.
with the state
State.
Yeah.
regulations by basically one
dog.
dog.
Yeah.
And so they didn't feel on that year that was such an important thing as the other things they were trying to get through.
Yeah, but
So-
that would have just sailed right through, because it's the zoning's always last.
Now, another thing which is somewhat controversial, and has been in a number of votes at the town meeting, is where in the proceedings of town meeting do certain important zoning things
Right,
come up?
after everybody's gone home.
Yep.
So they should actually be before the things that people are there for.
Well, it's a matter of opinion. Myself, I think most of the budget stuff is not controversial.
Right.
And goes right through.
Yes.
So why don't you put that at the end? And if there's only 200 people there, or 125 people there, instead of 400 or
Right.
whatever, it's not as damaging. But I'll let you folks know, back around, I'll say 79 or 80, I personally worked to get a housing, 54 units of housing from the federal government. And this town got a grant, total grant, for a turnkey project for 54 units of housing, over $1 million back,
Yeah.
that money. And it should have just gone right through and taken care of through the selectman's office and so forth. But then, at the sort of the last stage of the project, one of the selectmen says, this is a big decision, I think it ought to go to town meeting. And the other selectmen agreed, and long story short is that some people in Central Village got together and didn't like it, and it failed by, I want to say, 4 votes. at town meeting. And so the town never got the $1 million project, and today they're crying for housing, okay? And to make matters worse, the town had to pay back $16,000 that we spent for engineering work to get to that point, and we had to pay it back to.
I mean, the same thing that happened with the
Yes.
Airbnb thing. They did, it
Yes.
wasn't presented in a clear
Right.
manner, or, nor any education was really going on, so it
Yeah.
just sounded terrible and.
Yeah,
and
well,
that-
the other part of that is that anybody can say whatever they want. You're not under oath at town meeting. You can say whatever you want. So there was a lot of false
False stuff,
information,
right.
stuff that came out. We all know that.
Yes.
And then they stand in line. So somebody who knows the facts stands in line to try to refute it, and somebody in front of them who hasn't spoken before, call the question.
Yes, that's right.
It's 11 o'clock
Yeah,
at
that's the way
night,
they do it.
and what do you think happens?
Yeah, well, our government runs as well as the United States government, so,
Oh, yeah.
yeah.
Or the
Oh,
state.
I think actually you should have run for town moderator.
no.
We would be, we would have,
Oh,
we'd have 5-day town meetings. Well, then everybody gets a, somebody needs to make a motion to adjourn, but I don't think I can.
I
do
take
it.
over your job.
Yes.
I make a motion to adjourn. Boy, I love doing that. I take your
Second.
job many times.
Second?
Yeah.
All right,
All in favor? Aye.
adjourned.
Okay, Val, thank you.